We're going to bring you back live to Lower Manhattan because it looks like the defense team for Harvey Weinstein is set to speak. Let's listen.
Everybody ready? Good? Okay. Good morning, everyone. Obviously, today was a procedural day. We are ready to start this jury selection tomorrow. As you heard, again, Ms. Aluzzi is attempting to silence us from speaking to you and speaking to the people of New York and country and the world, frankly. Here we are looking at a circumstance where she stands up in front of a court and calls my client a predator. Mr. Weinstein, again, has a right to a fair trial. I think she believes he's convicted already. That's not how this works. So we are here hoping to pick and find a fair jury, and we believe that that's going to be possible. And we're going to continue to press on and remind everyone that in this great country, you are innocent until proven guilty, and no evidence has yet been presented to a court or a jury or trier of any fact, and that is why we are here to start this trial. I thank everybody for their time. I'm going to let Damon speak about the motion issues today. Well, we talked about a possible sequestration of jury just based on all of the media attention this case is obviously getting, and obviously it is no surprise to any of you. You're writing about it. The fact that there is a potential LA situation going on, and based on the fact that we don't have any information about that, we are anticipating, if this were to happen as the trial unfolds, what that may look like. So we think it's a safer bet if a jury was sequestered than anything that was, that could potentially happen would not have an effect on this trial moving forward.
How do you feel about the decision? This is at this late date?
I'm sorry, say that again?
Is the state still issuing witnesses?
I have no idea what the state's doing.
How do you feel about being precluded from calling the detective?
Obviously, I think that that's going to be an argument that we can deal with later on. I think it's really interesting anytime an investigator in a case is precluded from testifying in a trial that they were so much a part of the investigation. So obviously, we'll address that as the trial goes on. There's other ways that we can get into that evidence. As you heard, we can cross-examine witnesses in regard to those questions. So we will be doing that.
Are you being abominable?
I'm sorry?
Are you being abominable?
I'm never abominable. Go ahead.
No, regarding your question, it's not a full preclusion. There may be instances where the detectives could be called, for instance, to prove up impeachment or things along those lines. So it wasn't a total preclusion, but it's going to be determined on sort of as the case goes on, I think is a more accurate description of what the judge ruled on.
What are the 7 photographs that are apparently delicate and sensitive?
We don't have any comment.
Are you expecting a black cute witness?
I'd rather just let it stand as it was in court. The government's attempting to introduce certain things into evidence. We're objecting. The judge is going to rule. I don't want to get into all of the facts regarding it. I believe the state did say they were going to attempt to call one of Mr. Weinstein's lawyers, possibly. We would object to that for obvious reasons, attorney-client privilege, things like that. But that decision, I think, the court made a ruling regarding some of those decisions which were beneficial for Mr. Weinstein, and regarding how else the state is going to try to introduce it. We're just going to have to wait and see, and we'll object.
Do you expect that your client's going to be indicted in L.A. during this trial?
We don't know what's going to happen. We're hoping not, for sure. I think if that happened, it would be pretty obvious as to why the timing would be very suspect. Mr. Weinstein's certainly looking forward to getting this case out of the way. We have no control over what happens in Los Angeles or anywhere else.
Mr. Turner, why do you think Ms. Aluzzi was trying to pull you out?
I think that in the end, the government doesn't want our side to have a voice. I think they believe that their side of this story is the only one that matters and the only one that counts. And that's what this trial's for. This trial is to show the jury, the state of New York, and the world that there's more to this than they would like everyone to believe.
And sorry, you interviewed in Chicago, you said you can get away with more in court than a mere attorney. Can you comment?
You know, I've commented on this over and over and over again. It isn't about getting away with anything. It's about the fact that these lawyers standing with me are just as competent and skilled to ask the same questions that I ask. As a woman, the effect on the listener is different. And when a woman has a conversation with a woman and questions a woman, the listener views it in a different way. Thanks, everybody.
What are you trying to focus on for jury selection?
Fair jurors. Jurors who can be fair and impartial. Have a good day.
Thanks, guys.
Those words from the defense team there speaking outside the New York Supreme Courthouse in Lower Manhattan. Of course, if you're in a state where the Supreme Court is the highest court of the land, the verbiage is a little bit different. In New York, the high court is called the New York Court of Appeals. The trial courts, in many states called superior courts, are Supreme Courts in New York. The reason why is because when New York consolidated its court system, they decided that there would be a judge handling a county or sometimes counties in the more rural parts of upstate, where that judge can pull a case out of city, town, village courts, lower court, so to speak, to the Supreme Court for a trial of a court of jurisdiction over a geographic region, a Supreme Court seat. So that's why the trial courts in New York are often called the Supreme Courts of New York State. So let's jump in now with some analysis. Retired LAPD Sergeant Cheryl Dorsey is with me this morning here on the Law and Crime Network. Cheryl, we heard from the defense, and we got that question in there about some of the comments that were attributed to her about what she can do in court versus some of the male attorneys. But let's hold that thought because we have more commentary coming from outside the courthouse in Lower Manhattan.
500 Pearl Street in the Southern District. I also represent Kaya Sokolow, who was 16 at the time that she was allegedly sexually assaulted by Harvey Weinstein. Her claim under the Child Victims Act is pending over here on Center Street in New York State Supreme Court. I also represent a woman, Jane Doe, who is yet to be identified at this trial. She will be testifying as one of the 3 Molyneux witnesses. She will be testifying in the course of this trial. Let me just say this. The last time I stood before this courthouse, before a crowd such as you, was at the beginning of the dawn of a different decade. It was 2011. And in 2011, I had the privilege of representing Nafissatou Diallo, the maid who we allege had been sexually assaulted and raped by Dominique Strauss-Kahn. Unfortunately, that case ended with the district attorney dismissing the indictment. But today, we start a new decade, a decade that has come so far in the Me Too movement. And today, we are beginning the process of holding Harvey Weinstein accountable for his actions. And so much has changed since 2011 because of Me Too. We no longer are strapped with the rape myths, and the jurors that will start selecting tomorrow and going through next week are in tune with the common rape myths, that people aren't necessarily raped in dark alleys at gunpoint or knife point, that women often know their perpetrator, that women often speak to the perpetrator after the crime has been committed, that women often don't go to the police or to authorities or tell their loved ones immediately after they've been sexually assaulted or raped. And this case will be a testament and will be a trial not only about Harvey Weinstein, but where we have come as a society. Because the rape myths that the defense keeps talking about people being actresses, about people having contact with Mr. Weinstein after the alleged crimes, those are the things of the last decade, not this decade. And I am very confident that New York jurors will see through those cross-examinations. As I indicated, I represent a Jane Doe. She will be identified by her name later on during this trial. She was raped in 2005 here in New York at Harvey Weinstein's apartment. And there will be more details about her, and I will address you about that. She will not be making any statements or doing any interviews during the course of this trial. And I would be remiss if I didn't mention one other thing, which is, considering that I represent 2 other women with civil claims, I should note that my client here, who's testifying in the criminal trial, has no civil claim. Her claims are barred by statute of limitations. She's not doing this for the money. She's doing this to hold Harvey Weinstein accountable for his actions and to help the victims in this case and the prosecution in this case. That is her only motivation. And I would be remiss, though, if I did not talk about the purported and alleged settlement that's been in the news over the last few weeks, because that settlement is one of the worst civil settlements that I've ever seen. It is a one-sided civil settlement, and my two clients, Waddell David and Kaya Sokolow, as well as many other women who have contacted me in the last few weeks, will be vigorously objecting to that civil settlement. It's the only civil settlement that I've seen that pays $12 million to the director defendants who we allege were part of the scheme to enable Harvey Weinstein. There are also millions of dollars going to class counsel. There are also millions of dollars going to vendors, secured creditors. And to make matters even worse, to the people who want to opt out of the civil settlement, they are trying to bind them by providing releases to the insurance companies and providing releases to the directors. And my biggest surprise, frankly, is that the Attorney General, the former public advocate, is not standing with me shoulder to shoulder in denouncing the civil settlement and making sure that Harvey Weinstein is held accountable not only in this courthouse for his criminal wrongdoing, but in the civil courthouse for the civil wrongs he committed. So I ask her to join me in objecting to the civil settlement on behalf of my clients and the other women who have contacted me. I'll answer a few questions if anyone has any.
You speak about a new era, but Harvey Weinstein was accused by almost 100 women, and here he's in court based on 2 cases. So how can you reconcile that with this very important?
Well, he's in court here based on 2 victims, but there's also a 3rd victim. I'm sure Ms. Allred will be talking about that victim since that's her client. But there are actually 6 women who are going to be testifying in this case, 3 Molyneux witnesses, 1 witness who's a predicate for the predatory sexual assault case, and then 2 main victims. It is a substantial case. The prosecution, in my view, has a very strong and compelling case. I expect the jurors to understand the case and to debunk the defenses and the cross-examination that I expect to happen. I don't believe will have any traction, and I expect there to be a conviction. The witnesses who will be testifying under Molyneux, which is the name of the case, I believe are very strong. Bill Cosby case is a great sort of piece of evidence for that. If you recall, in the first trial in Bill Cosby, ended in a hung jury. There was only 1 equivalent of a Molyneux witness. And then in the second trial, which ended his conviction, there were numerous. So I expect the same thing to happen here. When you have 6 women testifying about a sexual assault and a rape, it is much harder for the defense to cross-examine each one of these women and try and attack their credibility. At some point, the jurors are just going to start to blame the defense and look like they're victim bashing, which is exactly what they're doing.
Doug, in bringing up your prior client, were you suggesting that the district attorney came to this case reluctantly?
Well, what I'm suggesting is that I've been on record that I believe this district attorney's office made a mistake when they dismissed the indictment in the Diallo-Dominique Strauss-Kahn case. I believe there was overwhelming physical evidence in that case. And I believe that people's views and how they want to prosecute cases evolve. And so I applaud Cy Vance and Jonah Luzzi for taking this case to trial and holding Harvey Weinstein accountable and for looking past some of the things that used to be what we refer to as rape and sexual assault myths and understanding that, again, people are not always, and usually not, sexually assaulted and raped in dark alleys at gunpoint and knife point, and that they're usually raped and sexually assaulted by people they know, and they often continue to be in contact with those people. And that is what this trial, in many respects, will be about, where we have come as a society. Yeah. You'd have to ask that question to the district attorney's office, but I have faith that they have put together a case that they believe gives them the best chance to obtain a criminal conviction. There's a lot of strategy as a former prosecutor myself that goes into that, and I won't speculate as to why they did or didn't do that. All right, thank you, everyone.
Go get it, Gloria.
Those words from Doug Wigdor. He represents several of the accusers of Harvey Weinstein. He talked there about the Molyneux witnesses. Basically, that's New York case law on the so-called other bad acts evidence that we hear in so many of the cases that we cover here on the Law and Crime Network. Of course, we're talking about the criminal prosecution of Harvey Weinstein, 5 sex crimes charges. Gloria Allred speaking to reporters right now.
Case of People versus Harvey Weinstein, for whom charges have been filed. That person is Mimi. I also represent the witness on the issue of sexually predatory conduct, and that witness is Annabella Shore. There were many issues discussed today, but for me, the most interesting issues were, first of all, the request by the defense to sequester the jury. That request was made because apparently the defense was worried that other charges may be filed by one or more other jurisdictions while this case is pending and in trial. And the concern was that somehow that would affect this jury that is about to be selected in this case, and that somehow they might need to make a motion for a mistrial if that happens, and if the jurors learn of it. It appears that it may be that they were concerned about Los Angeles. I'm licensed in California and also in New York, and that there have been news reports that there has been an ongoing criminal investigation by the Los Angeles County District Attorney's Office for 2 years, and that it may be that charges will be filed soon. Date unknown, and not to a certainty yet that charges will be filed. But apparently that's making the defense nervous, and so they made that request. That motion was denied. The jury will not be sequestered. Ordinarily, juries are not sequestered. There have been some notable exceptions in high-profile cases, like in the case of People versus O.J. Simpson, where I also represented the family of Nicole Brown Simpson. Jury was sequestered. Also, the well-known case of People versus Scott Peterson, where that jury was sequestered. I also represented the key prosecution witness, Amber Fry, in that case. In any event, the defense motion was denied. I also thought it was very interesting that there was mention of Black Cube in the court today by the prosecution, and that the prosecution is seeking to have the defense stipulate to a witness in reference to Black Cube. There have been many news reports about the allegation that Black Cube was hired by Mr. Weinstein's defense attorneys to investigate the certain witnesses or certain individuals who might be speaking publicly about what they allege was their truth about Mr. Weinstein. And it has come out that that is true, that there has been such an investigation. And so the prosecution indicated that if the defense does not stipulate to that, then they are going to want to call attorney David Boies to the witness stand in reference to Black Cube. So we'll have to see what happens on that. That's going to be a very interesting issue. Finally, I would say another interesting, but not the only important issue in the case, but to me interesting, was the fact that there has been a media blitz by the defense in the last 72 hours. That was brought up by the prosecutor, Joan Luzzi, and she felt that what the defense was saying was, in her words, abominable. And I would agree with that, because the defense did talk about this weekend certain witnesses that are going to be called by the prosecution, certain people who are alleged to be victims. and that they also talked, according to the prosecutor, about certain sealed discovery matters. And Donna Rotuno admitted to having been interviewed this weekend, which we all know she was. And while the court did not grant the motion to essentially have a protective order so that the defense cannot talk about this case, the court was very clear that the defense was not to talk about witnesses in the case. And I think what the defense was trying to do this weekend and prior to that was to make an attempt to, through insinuations or direct statements, that somehow some of the witnesses could not be believed. And trying to undermine the witnesses, and why would they do that now before the trial starts? Obviously to try to have an impact on the jury pool, to then raise doubts about some of the witnesses the prosecution will call. And I think that's extremely, extremely unfair to the witnesses, and that the jury should only judge the witnesses' testimony and their credibility based on what is admitted in court, and not based on any arguments of the defense, either inside or outside of the courtroom. And so that's going to be very important. So last point that I would like to make is this has been a journey to justice. And, you know, as I've said many times, my firm has been the leading women's rights law firm in the United States for 44 years. And we are dedicated to making sure that women enjoy their rights and not be intimidated or retaliated against because they assert their rights. So I think both of my clients in this case have been very brave, very courageous, because they're willing to testify under oath, to tell the truth, the whole truth, and nothing but the truth, so help them God. And they're doing so because it's in the interest of justice for them to do that. So I admire them, I honor them, and I'm very pleased to be able to represent them. And I'll be happy to take any questions.
Why is it important for the jury to hear evidence of Black Cube?
Why is it important to hear evidence of Black Cube? I think I will let the prosecution say when they are ready to indicate why they think it's important. But I do think it's important because it has been very intimidating to some people to learn that they were being investigated even prior to their saying anything. And, you know, there are reports that individuals sent by Black Cube were not forthright about who they were, and that would cause any person who may have been the subject or target of investigation to feel that, you know, their privacy is being invaded, perhaps violated, and it's very upsetting to think that they're being investigated when they have done nothing wrong to justify such an investigation.
What would be the best outcome for you?
The best outcome will be not only a fair trial for Mr. Weinstein, but a fair trial for any witness who testifies. Because often witnesses do not feel that they're being treated fairly, that the defense is being treated fairly, the accused, but not the witnesses for the prosecution. So regardless of the ultimate outcome in this case, the justice system is working. Even though there were 60 to 90 women who spoke out publicly, only 2 are alleged to be victims in this case for whom charges have been filed. And there may be others, well, there will be others who allege that they are not only witnesses but victim witnesses, even though no charges have been filed for them. So accountability is what this is all about. That Mr. Weinstein finally has to confront in court the witnesses against him and the evidence against him, in addition to the testimony of the witnesses, and that women are being very brave. And I'm just so proud of them for that. So thank you. Anything else? Okay, good. Thank you.
Attorney Gloria Allred there representing several of the accusers of Harvey Weinstein, the former movie mogul facing 5 sex crimes charges in New York, speaking in part about Black Cube. That's the intelligence gathering agency, private intelligence. It's mostly corporate intelligence that is alleged to have gathered information on some of the accusers of Harvey Weinstein. So just to put some context in that, we're going to take a break here on the Law&Crime Network and be back with more coverage of the Harvey Weinstein criminal prosecution, including Jesse Weber, who is inside the courtroom for us this morning.